In terms of my background and what brings me to this place today is sort of a history of being a researcher. Some of you know my work, subtractive schooling, and doing an ethnography in this public school in Houston over a 3-year time period. And in 1999, I ended up testifying in a federal court case that involved the State Board of Education and the Texas Education Agency with plaintiffs that were being represented by MALDEF attorneys, Mexican American Legal Defense and Education Fund attorneys. And the plaintiffs were young people that had taken at that point, it was the TOS test. And after that came the talks, and now we have a brand new STAR system that I think I might be able to touch on today. But at that point, it was the TOS test, and the students, though granted multiple times to take the test at the exit level, some taking the test as many as 6 times, still were not able to get a high school diploma, despite the fact that they were good students. That federal judge would not allow any kind of testimony into the court case that touched on the actual inequalities of the school. He wouldn't allow that kind of testimony, which meant that opportunity to learn the curriculum was not a factor that found its way into arguments, or in as much as they did, he quickly discounted that. As if you can artificially separate these two, the results on the test with the actual opportunity to learn the curriculum to which the tests were connected. He ruled in that court case that he agreed with the plaintiff's attorney that, or attorneys, that whereas the attorneys were able to demonstrate sufficiently that there was a disparate impact on African Americans and Latinos, that impact did not reach a constitutional level of harm. So he actually agreed with the arguments, which made it difficult to appeal. So it was a kind of a sleight of hand, and it made it difficult to appeal to the next level. But he was able to make his claim on the basis of the multiple opportunities to take the test, and that a high school diploma is not a property right. So there's important details to law there that led basically to a loss in that court case. In 2009, Representative Olivos appeared again in the form of House Bill 3, which was a pretty disastrous bill that led to the current STAR system of accountability that involves 12 end-of-course exams for kids in the recommended curriculum, 12, shooting up the number of testing days right now. I mean, this got launched right now. The kids are testing this week. But it's 12 end-of-course exams for kids in the recommended track. Once it all gets unfolded, right? It's not all fully implemented yet, but it's affecting this year's entry 9th graders, and it'll shoot up the number of testing days from 28 to 45 out of a 180-day school year, and it will conflate standardized test scores for each of the courses, the 4 core courses at each grade level, with the actual course grade, with the test counting for 15% of the course grade in each of the 4 core courses. This is terrifying. A lot of the affluent parents, their kids are not always good test takers. Actually, there's a whole segment, regardless of class or race, that will never ever test well on these standardized testing exams. And now for your grade in a course to be conflated with a standardized test score is unprecedented in the history of testing, although there are other states right now experimenting with it. And it's also unprecedented in Texas. There's also no research base for this. But I'll talk about the myths shortly of testing, but obviously it doesn't matter when there's powerful, very moneyed agendas attached to this system.